If you've been driving around Kansas this summer, you've probably seen a bunch of signs saying vote yes or vote no. So what's all that about? On August 2nd, the people of Kansas will go to the polls and vote on the Value Them Both Amendment. The Value Them Both Amendment will leave abortion regulations up to the state legislature, and it will also forbid taxpayer funding of abortion. This amendment goes back to a state Supreme Court decision from 2019, in which the Kansas State Supreme Court held that there was a fundamental right to an abortion. And in that case in 2019, the state court was considering a state law that banned the dilation and extraction procedure, which is a gruesome procedure, dismembering a baby usually in the second trimester. So it's the most common means of abortion in the second trimester that the state legislature attempted to ban. And the state Supreme Court said it couldn't do that because there was a fundamental right to an abortion protected by the state constitution. So what in the state constitution gives this right to an abortion, even in the second trimester? It's from section 1, right at the beginning. The state constitution says, all men are possessed of equal and inalienable natural rights, among which are life, liberty, and the pursuit of happiness. So, nothing obviously about abortion in that sentence, but in Kansas, it doesn't matter that the U.S. Supreme Court has recently overturned Roe v. Wade and Planned Parenthood versus Casey, leaving abortion regulations up to the states. Because in Kansas, we're stuck with this state Supreme Court decision that says that abortion regulation is unconstitutional because it goes against this language of the Kansas State Constitution. Okay, so the Kansas State Supreme Court looked at the history of the Constitution and its language. The Constitution was drafted in 1859 by the Anti-Slavery Wyandotte Constitutional Convention, and it was adopted when Kansas became a state in 1861. In those years, both when Kansas was a territory and also in its first years as a state, Kansas regulated abortion. It banned abortion from the moment of conception, and it punished abortion as manslaughter starting at the time of quickening. The state Supreme Court says this is irrelevant. It doesn't mean that the state is free to regulate abortion because it looks at the underlying principles of the language of the state constitution. And to understand its underlying principles, it uses the thought of John Locke. So the state Supreme Court says there's this fundamental right to bodily autonomy, and they point to John Locke as someone who explicated that right to bodily autonomy. But as it happened, John Locke himself did not advocate for a right to an abortion. And in fact, in one of his writings, he even indicates that there might be something morally wrong about abortion. And so the state Supreme Court, in its radical decision, goes even beyond the most expansive and radical views of individual autonomy that were present at the time of the American founding and the Kansas founding. So the U.S. Supreme Court, back in the 1970s in Roe v. Wade, also found a fundamental right to an abortion, which has now been struck down by the court in the Dobbs case. But in Roe v. Wade, the court said that the right to an abortion was fundamental and it was subject to strict scrutiny. This meant that for the state to regulate abortion, there had to be a compelling state interest, and that in order to achieve that compelling state interest, the state had to use the least restrictive possible means. And so this had the practical effect of getting rid of pretty much every abortion regulation that was out there. A few decades later, in Planned Parenthood versus Casey, the court also upheld the fundamental right to an abortion, at least before the point of viability. But instead of subjecting it to strict scrutiny, which forbade pretty much every regulation one could imagine, it now subjected abortion to the undue burden standard. The undue burden test meant that, among other things, states could generally regulate abortion in more modest ways, like through waiting periods, through counseling, through parental consent laws. Okay, how is this history relevant to Kansas? Well, the Kansas State Supreme Court looked at those two standards that the U.S. Supreme Court had adopted, the strict scrutiny standard in Roe, which struck down pretty much any abortion regulation one could think of, before viability at least, and then the undue burden standard in Casey. And the Kansas State Supreme Court intentionally said that the Casey standard was wrong, and they chose the strict scrutiny standard in Roe to apply to the Kansas State Constitution. So practically speaking, this means that the Kansas State Supreme Court has taken the most radical route possible of interpreting the state constitution to allow abortion. We already know that the way the court's going to interpret this fundamental right means that gruesome procedures conducted in the second trimester can't be regulated by the state. But it also opens the door to other kinds of regulations that would be subject to the strict scrutiny standard and would probably be suspect to the court. So things like that the Kansas legislature has already adopted, like mandatory waiting periods, mandatory counseling, parental consent, all these things are now called into question. Moreover, one wonders if the state Supreme Court thinks there is such a fundamental right to an abortion, if one day they could require the legislature to fund it through tax dollars. And so that's why we need this amendment, is to take things out of the hands of this radical state Supreme Court that wants to go back to the early 1970s and allow the most unlimited right to an abortion imaginable. So in order to preserve the laws that the Kansas state legislature has already imposed on the question of abortion, it's essential for this Value Them Both amendment to be passed. It's already gone through both houses of the state legislature with a 2/3 supermajority vote, and now it's up to the people of Kansas on August 2nd. And if this amendment passes, the state legislature will be free to regulate abortion, the current laws regulating abortion will stay on the books, taxpayer funding for abortion will be outlawed, and maybe more importantly, it will take the twisted interpretation of the state Supreme Court regarding that first provision of the Kansas Constitution that so beautifully protects the natural rights of all human beings. And it will assert that the people of Kansas do value them both, that this language of the Declaration of Independence applies to all human beings at every stage of development. It's not just for some classes of human beings to persecute and oppress others. So if you live in Kansas, I strongly encourage you to go out and vote on August 2nd, to register to vote if you're not already registered. If you're pro-life, I strongly encourage you to vote yes on this amendment so that we can say that the Kansas State Constitution does value both lives, the life of the mother and the life of her unborn child. And even if you're pro-choice, but favor some modest restrictions on abortion like parental notification laws, second trimester restrictions, informed consent laws, then I strongly encourage you to go out and vote yes, because the state Supreme Court has already strongly signaled that it's poised to take away all of those modest restrictions on abortion and leave Kansas as one of the most unrestricted places for abortion in the United States.